So being one of those people who gives their opinion about stuff on YouTube, somebody asked me about SOPA, or a couple people actually asked me about it, and I didn't want to make a video simply because I thought, well, pretty much everyone already knows at this point, and I was skeptical of a lot of the talk at first because people were saying things like, oh, YouTube and Facebook are going to get shut down. And my opinion was that seems about as likely as a celebrity going to prison for drugs. That's not to say that it couldn't have happened, but the difference between, say, the average site or the sites that they say they're going to try and go after and a site like YouTube, which is owned by Google or Facebook, the difference between, BitTorrent tracker site and YouTube is an army of lawyers. And so it actually came as a huge surprise to me to see that Google was actually concerned enough about it to do their portion of the blackout, as well as lots of other sites like Wikipedia. And I feel like sometimes whenever the issue of copyright comes up, it seems like the number one most tangible change that I've seen in my lifetime is how much media is out there and how easily accessible it is because of the internet. So these sorts of battles between new and old media have now reached a point where a army of lobbyists from old media, Hollywood, television, that sort of thing, can get a bill introduced into Congress, and then the actions of new media sites like Google, Wikipedia can stop this bill through their protests. So it's sort of a contest of, one side's army of lobbyists versus another side's mass action, and it seems that mass action and maybe some backdoor army of lawyer stuff as well was enough to stop this. I think that they're just going to keep going after piracy sites no matter what, because no matter what laws new laws they do or don't pass, it's still going to be technically illegal. So I don't expect them to stop their efforts, although it just seems that all of their efforts are completely inept because they don't really have a handle on the new technology. And I was reading in a book about film that the film companies, the motion picture production companies who were making the movies in the early days were also the people who built the theaters, and so having that kind of control over their market is something that they're used to, and as was pointed out in the TED Talks video about SOPA, that media companies old media companies are used to everybody having a centralized everybody goes to the television, these things are on at a certain time, and as technology has evolved, it's just eroded their capacity for control. If anything, that's just interesting, because the entire concept of intellectual property is somewhat interesting when you really stop and think about it. I do think that if you write a book or something like that, that you should have the right to get royalties from having it published without copyright or without intellectual property. Anyone could just take a book by any author and publish it without paying the author any money. On the other hand, there's strange cases of intellectual property where you have, I'll post a link to a New York Times article where there was a company in Vermont and they had a phrase, "eat more kale," that they were using on t-shirts. Now, this sounded a bit too much like "eat more chicken," which is the advertising phrase for Chick-fil-A, which is a Christian company, and so Chick-fil-A sued this company, this much smaller company in Vermont, not because they were using the same phrase, but because they were using a similar phrase. So not only can copyright and trademark and intellectual property allow you to own a phrase, and that phrase's use within a certain domain of things like advertising, but it can also you can try and claim ownership of what might amount to mental associations with that phrase. So they want the consumer to fill in the blank of the eat more with chicken. You know, Chick-fil-A wants you to hear the phrase "eat more" and think chicken, and then think Chick-fil-A. If somebody else comes along and says "eat more kale," they say, "Oh, now they're stealing that little bit of the consumer's mental association away from our advertising campaign, and we're going to sue them and cease and desist." I don't know if they actually have a legal groundwork to stand on, or if it's just a case of a larger company hitting a smaller company with a lawsuit, which is usually enough to right a wrong, cause the smaller company to have to back down or change what they're doing. There was another case also out of Vermont of a small brewery making a drink called the Vermonster. Monster Energy Company, or its parent company, sued for them to stop using the phrase Vermonster, even though the Vermonster drink was around before Monster Energy drink, and they didn't really have a copyright claim to stand on. So sometimes intellectual property means not even, well, none of it really means owning anything tangible, but owning things which are intangible, or which can be digitally copied. That makes some sort of sense, because when you're talking about books, you're actually talking about, you know, words that can be copied or published. But when you're talking about advertising phrases, that's where I think intellectual property starts to get really weird and abstract, and just seems like more of it has to do with economics than what's actually you know, fair in reality or anything like that. And intellectual property amounts for a vast amount of the economy, not necessarily what we think of as intellectual property, like entertainment and books and that sort of stuff, but patents and that sort of thing is pretty much the way what the modern economy is founded on. And it's very difficult to imagine living in a world like ours without intellectual property laws, but they shape society in a distinct way.